Morning. It is March 10th. Committee. Yeah, sorry. Okay. We are having our first committee meeting back after town meeting week. And we are taking up S-181. We have Ledge Council here with us. It's a short bill, but we have some witnesses here. We'll be testifying on it. And Michelle, the floor is all yours.
Thank you. So good morning. For the record, Michelle Childs, Office of Legislative Counsel, and we're looking at S-181 as introduced. So I know this committee has dealt with deferred sentences before in various ways, but I'll just give you a little kind of recap, reminder about what deferred sentences are. So essentially, deferred sentences is a sentencing option whereby a court defers imposition of the sentence. So there's an adjudication of guilt, but they don't impose the sentence and rather place the defendant on probation. And so typically that's done between a written agreement between the prosecutor and the defendant. However, a court can do it without that written agreement between the parties in certain circumstances, but not for listed crimes. In both instances, a pre-sentence investigation is required. And I'm sure some of the other witnesses can talk to you more about what's entailed in a pre-sentence investigation. I'm sure the chair probably is more familiar than I am with it, but I do have some materials from DOC that kind of outline the policy for PSIs, and I can provide that link to Emory if you're interested on that. But essentially, PSI is like an investigation that's done by DOC to provide for background information to the court in making a sentencing determination. And so right now in the statute, you'll see when we walk through the language that, like I said, pre-sentence investigation is required prior to imposing a deferred sentence. Just as a reminder, if the defendant successfully completes their term of probation, then an adjudication of guilt is struck and the person is discharged, and the records related to that particular offense are expunged. That's that kind of one area that you didn't change last. Well, two areas was diversion and deferred sentences when you did your big ceiling bill last year. So records related to an offense that when somebody successfully completes the first sentence is expunged. But if they violate probation, the court is required, it's shall language is required to impose the sentence. So it's kind of like, here's your shot, you comply with probation and the certain conditions of probation that are related to your offense. If you do that, then you're discharged, your guilt is struck, and your records are expunged. If not, then you're going to serve the sentence. So if you look at the language, as the chair mentioned, it's pretty short. So we're working in Title 13 in the chapter regarding sentences. And so you see it's amendment to section 7041 for deferred sentence. So you see subsection A addresses the kind of default usual circumstances where the court can defer a sentence if there's a written agreement between the defense and the prosecution. And you'll see it's striking the language on line 14 and 15 of a requirement that there's a PSI done prior to imposition of the sentence. Subsection B is where I talked about the option for the court to still issue a deferred sentence, even when there's not an agreement between the prosecution and the deferred, but the court can't do it in cases of listed crimes. And you'll see on page 2 in subsection B, the language related to the PSI is struck. So that's in subdivision 3, where it current requirement that the court orders a PSI. And then subdivision 5, that prior to doing the deferred, the court has to review the PSI and the victim impact statement with the party. And I'm wondering whether or not it's a policy decision for you, but I don't think I had noticed before that the PSI and the victim's impact statement are there. So you left the victim's impact statement in subdivision 4, so you might find that on the strike after pre-sentence investigation on line 11.
I noticed that earlier too. And
thanks. Sorry, I didn't catch that earlier. Sometimes we can see
that's the more I had.
was. And then the rest of the changes there are just, some little, technical amendments that I added there for clarification.
Michelle, just to make sure the process is understood here, this would not apply to this wouldn't apply to listed offenses, this change, right?
Well, you couldn't do a deferred sentence for, like, the court can't do it on its own.
Right.
For listed crimes. There can be an agreement between the prosecutor and the defense for if it was a listed crime. But this proposal here is taking out the PSI.
Right.
In both instances.
For the listed offenses as well, when
there's no distinction in subsection A around what can be if there's an agreement between the prosecutor and the defense. That's not limited to certain offenses. All right, does that follow? And so, and we can craft it however you want. But just this language right now is just taking out the requirement for a PSI at all circumstances prior to issuing the deferreds. You can, the only distinction around, like with the listed crimes, is that the court can't order one over the objection of the state's attorney for a listed crime. And then you have like certain offenses in subsection C that are just out no matter what. So you could, do, if you wanted to, and you just make it, we could, structure it so that you just say in terms of listed crimes, which again, it could only be under subsection A. If it's a listed crime, there has to be the PSI, and if otherwise, you don't do the PSI.
Yeah. As I'm rereading it now. Back to me. So, yeah, I would tend to lean in that direction, that there would be the requirement for a PSI for listed offenses. Non-listed offenses, after an adjudication, then the judge can impose a deferred sentence without requiring PSI. That's what I was trying to get at.
Okay, sure.
Senator Morse.
Yeah, I think you made sense. So what this is saying is upon adjudication of guilt and so forth, for the non-listed offenses, even though the state's attorney and the defense has agreed upon this, can the judge in his or her own power still say, no, we're going to go with PSI anyways, I want a PSI? Does that still give them the ability to do that?
That would probably be a question for the court. I would think that they could, that there's no reason why they couldn't request one, but I'm not entirely, you probably want to talk to the practitioners about the regularity that for PSIs, that sort of thing.
Because it says to be able to eliminate the requirement, but still to say.
Right.
Thank you.
Yep. And I was going to say, just based on the chair's question there about that, was that, you might want to just put something in there, even if it is something that the court can, ask for anyway. You might just want to put something affirmatively in there with the removal of this language.
Yeah, that's one thing that I was thinking. But really, the underlying point is to try to allow a bit more discretion for a judge to impose a deferred sentence without necessarily requiring a waiver from the state's attorney after the case is over and after all the evidence has been seen. Because, well, I don't want to speak for anybody else, but I think it's something that just clears up a little bit of the bureaucracy for the length of just offenses when a judge may see that a deferred sentence is appropriate. So, okay. Any other questions, Michelle?
No, so let me just review with you what I think that you want in the amendment. And I know you've got to hear from witnesses, which is Just a clarification that, so on subsection A, what I'm going to do is break it out, is that PSI would only be required for listed crimes.
Yeah.
When there's an agreement between the defense and the prosecution. Subsection B, it would still be out as it is in on page 2 in subsection B, although I would on subdivision 5 just unstrike and the victim's impact statement with charges on that.
Yes.
Oh, and I'll add something just clarifying that the court presents for a case.
Yes. Thank you. Next up, we have Judge Zonin.
Good morning. Tom Zone, Chief Superior Judge. The bill S-181, I've listened to the testimony and your questions. It's important to keep in mind that if you go forward the way it's written, and Senator Norris, you asked the question, yes, the judge can still require it. In fact, under 28 VSA section 204, there are specific requirements for judges being able to order PSIs. There's also there's also components that you don't have to order one. Oftentimes the parties will agree to move forward without a PSI. And in this situation, you're talking about, for instance, listed crimes. Well, stalking is a listed crime, as is domestic assault. And so they're misdemeanors, but a judge would still could still require a PSI. However, if you went forward the way your draft is, the parties could say, look, we don't need a PSI. We don't need, DOC is busy. We don't need them to do this. We have enough information. It's an agreement to a deferred sentence. We don't need a PSI. And so I think it's a policy decision for the committee and the legislature, but the fact that you don't require it doesn't mean that it's never going to happen. A judge can say, I want one. As far as the second section, subsection B, that came in years ago when the legislature made a policy decision to allow courts to be able to impose deferred sentences over the objection of the state for certain crimes that were not listed crimes. And so you cannot impose a deferred sentence for a listed crime unless both parties agree. The practical import of how the changes under the bill would affect that section, I think, can be best illustrated by comments that were made during my retention in 2019. In 2019, I was up for retention, and one of the evaluations pointed out that it was a DOC employee. Apparently, said something like, "I work for DOC," and it said nice things about me. It said, "But he orders PSIs for misdemeanors, and we don't need to be doing PSIs for misdemeanors." And Senator Benning looked at me and smiled and said, "Did you order PSIs for misdemeanors?" And I said, "Yes, and I can tell you why." And it was because of this statute. Because what was happening was the court I was in, there was difficulty sometimes between the parties moving ahead with cases. There was the potential from the facts that someone might well be a situation where they would possibly qualify for a deferred sentence after a sentencing hearing. And sometimes, oftentimes, the state would say, no, we're not going to agree to waive the PSI. We're going to require DOC to do the PSI. And so DOC would have to do a PSI for cases of unlawful trespass or things like that. And so DOC was saying, why are we doing that? And the simple answer was because it was required for the court to be able to consider this. The court could not get to a potential deferred without that. And so I take no issue with these changes. I think that the changes provide flexibility to the court. It has the potential to actually assist judges in moving the backlog in ways that we can't now, because a deferred sentence is something that if the parties are willing, if the judge is going to consider it and the state won't agree to it, we don't sometimes need a PSI depending on the specific facts of the case if the parties can get the court sufficient information. And in the cases where the judge believes there's questions and wants additional information, having it as a requirement to be filed does not remove, again, the ability of the judge to order it.
That's helpful. So I guess the one question I'll ask is with the proposed changes that we were just discussing. Well, first, it sounds like you may not need that affirmative language based on what you just testified. The affirmative language saying that the judge can still request a PSI.
I think that you're correct. Under Rule 32 of the Rules of Criminal Procedure, there's provisions there that talk about pre-sentence investigations. And again, under Title 28, Section 204, the law does talk, the statutes do talk about PSIs. And so you have to read them all together. And the fact that this doesn't require it, I don't read that it means that the judge can't order it under the other statutes, and we still can move ahead.
Thank you. And the second question, with the other proposed changes, generally speaking, do you think that the bill would create more efficiency in the courtroom to help clear the backlog if the other changes were implemented?
When you say other changes, are you talking about that you still need one for the
Listed offenses,
listed offenses?
unless the state agrees to waive it. Yeah.
I think it would. If that removes a whole category of cases that you have to have it done by statute. And so I think the more of a requirement that you take away, the greater flexibility for the parties to take care of the cases in a more timely fashion based on the specific facts of the case. Because again, every case is not a one-size-fits-all model that requires a PSI. The parties may know the individual. There may be, under Title 28, Section 204, if there's been a PSI done a year or two before in a case, you're not required to have a PSI in a case, but here it would still require it if you're saying you still have to do it, even though everyone agrees, well, we just did one a year ago. We don't need another one.
Oh, actually, one last question. So before sentencing, is it fair to say that a judge would have all of the information that they need to determine whether or not a deferred sentence is appropriate without necessarily needing the PSI?
Sometimes. There are circumstances where I think the parties would agree that they have sufficient information and they're comfortable going forward. Not all the time. And in those circumstances, the judge would be able to say, no, I think that we need a PSI.
Thank you. Committee, any questions for Judge Silva? Okay. Thank you, Judge. Appreciate it.
Thank you. Have a great day. Take care.
Okay. Yeah.
Morning.
Morning.
Hi. Hey. It's Matt Blair, Defendant Justice. I don't know what you want me to say about this. I know a lot about this particular section of the law because during my 25 years in this, it's been amended 4 times, 5 times. The way it currently sits is a result of compromises over a period of years where when I was first, the deferred sentences have been around for eons. So that's nothing new. Most every state, I think every state has something similar to it. They call it something different, but effectively, you plead to something, you are either on probation or no supervision at all, and for a period of time, if you don't do anything wrong, the charge gets dismissed and the record is either sealed or expunged. Many states have the opportunity to request one of either a deferred sentence or something like it over, without consent of the state's attorney. When I was first DG and when I was practicing regularly in the courts, Vermont did not have that option. And over the years, it was one of the things where the statute was amended to allow defense to request file a motion with the judge to request that the court impose a deferred sentence over the objection of the state's attorney. And then the court could decide whether it was appropriate or not. There was a lot of consternation over about a 5-year period over whether that should occur and under what circumstances, what cases, what things might be excluded. And you see some of that in the statute. And one of the things that previously there was never a requirement with a deferred sentence that there were no exclusions, number one. And number two, there was no requirement that PSI ever occurred. But as part of the compromise, ultimately legislatively, because I don't think that over the time, the state's attorneys never consented to having a deferred sentence over the objection of the state's attorneys ever. But to kind of throw them a bone, said, well, what if we give you, what if we require PSI in cases? That was one of the things that was put in there, and then there were certain things that were excluded. So historically, if you go back, more than 25 years, deferred sentences didn't require PSI, but it was something that came in during the course of this evolution of the deferred sentence statute to what we have now. What I am understanding, and I don't want to speak for the state's attorneys, or at least all state's attorneys, but both sides, prosecution and defense, understand that there are some cases where you just don't need a PSI to do a deferred sentence, and requesting one just increases the likelihood that the plea agreement might fall apart. It takes a long time now it's even worse for the Department of Corrections to produce PSIs, given their shortage, staffing and the like. And again, I'm not speaking for all state's attorneys or any per se, but I know I've had personal conversations with individual state's attorneys who are like, we don't need this. It's really just kind of tying things up because we're waiting on PSIs that we really don't need. We know what we need to know about the case, and we wouldn't be doing this going forward in the past. Now, so I think as a practical matter, there's some level of agreement. I don't want to speak for state's attorneys, that between lawyers who do these cases, that PSIs are not required in every case. And as I got the end of Judge Zone's testimony, he says where, one size doesn't fit all, and there are cases where you don't need it. That having been said, judge can always order a PSI anytime he or she wants one. So there would be nothing preventing a PSI from being ordered by the court if the court says, before I accept this plea agreement, I want more information. And the parties can, do what they need to do to either support the plea agreement or argue their motion for a deferred objection to the state's attorney. So, from my perspective, all this is doing is kind of going back to historically what we had. That there was, the arguments at the time, and I understand people, carving out their political space in these discussions. State's attorneys talked about the whole system's going to grind to the halt. Defense lawyers are going to all file the request for deferred sentences in every case, blah blah blah, and but a bunch of other arguments, and none of that ever came to pass. Just because we have, like I said at the time, we have motions to dismiss and suppress that are available to us all the time. We don't file those in every case. We only file them in the cases where it's appropriate. Then there are some that are closed cases, and that's what we litigate about. That's what lawyers are there for. So none of that actually happened. So these kind of incentives or kind of political bones that were thrown to satisfy some of the concerns early on. The concerns haven't been in the past, and I don't see a reason why we can't go back to what we had. In fact, state's attorneys, some of whom who I've spoken to, have also agreed that kind of let the lawyers do the lawyering and make a decision about what's the good resolution in the case, and if the judge approves it and understands of what each side is saying for a case to have a deferred sentence. There's some number of cases that don't require a sentence investigation. So I don't have any problems with the bill. And to me, it's really just going back to, you know, it goes back to the time when I was practicing regularly for 15 years in the courts. And so, you know, I always say that, you know, in September or August of 2001, my legal career went into suspended animation. So I remember everything that happened before, you know, August of 2001. And everything that happened after that, it's like what happened in the legislature since then. To me, this is just going back to the way I used to practice. And I was comfortable with that. And at the time, I wasn't thinking legislatively at all. I was just like, okay, that's the law, let's do it. And that's the way we worked. State's attorneys didn't have any issue with it at the time, but, you know, I don't, and I regret it, you know, if you've ever testified, but I don't know what they're to say. But to me, this is just going back to the way I was used to practicing. It seems to represent a recognition that it wasn't, it gives flexibility to decide to resolve cases in the manner that they see appropriate. And if the judge has concerns about it, they can always say, no, I really want to be a silent case. So it doesn't limit any options to the court. It gives flexibility to the parties. And it goes back to something that has historically been done for decades. So I don't see a problem.
Thank you. Trevor, let's start.
Quick question, Matt. So you said you wouldn't have any problem with the bill. Is it fair to say you support the bill?
Sure. Yes. Thank you. And I will say too, as things are right now, there's nothing terrible going on. This just kind of tweaks it. I think gives a little more flexibility to the parties to do what they want to do with cases, and doesn't really take anything from the court's power or ability to get more information with the PSI if they want to. So,
Thank you.
yeah, no problem.
Any other questions? Okay, great. Thanks. One quick second, sorry, it's one quick second slide. Can you reach out to Haley Summers and see if anybody on probation and parole might be able to testify on this? That would be amazing, but if not, just at some point within the week, if there's availability, we'll carve out 20 or 30 minutes somewhere. Thank you. Okay, sorry about that. Floor is open.
Good morning, everyone. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. Thank you for having us in on S-181. I'm going to echo the last statement I believe the Defender General just made. We don't know what the problem is out there. We agree that PSIs are not needed for all of the non-listed offenses, and that's why we often will agree not to need one. And that's currently in statute that we can waive the requirement for the PSI. So we're not aware of this issue of that we're demanding these in unreasonable circumstances. If there's the state's attorney believes that the PSI is needed, that they have a reason for that. And so we're unaware of what the issue is. One thing we did want to highlight for the committee is a reminder that our listed offenses, and we've created this list historically around offenses that sort of our outside of our big 14 are our most heinous crimes in terms of personal victim injury. But there are a number of statutes that fall outside of that fall into this non-listed category. And we just wanted to remind the committee of that. A few of them, I don't mean this to be sensational, but certain non-listed offenses that are misdemeanors not misdemeanors and felonies, domestic terrorism, possession and use of weapons of mass destruction, willful and malicious injury caused by explosives, the entire chapter 64 of sexual exploitation of children, which is possession of child porn, use of a child in a sexual performance, et cetera. So those are offenses that would fall into this, that potentially deferred could be offered without the pre-sentence investigation. As Judge Soni testified and the Defender General testified, the court could, of course, order that. But we just don't understand why we would want to take away the state's attorney's discretion there. Again, if the state's attorney that probably that a PSI is needed, then they will waive it. But if they haven't waived it, they have a reason. And so just this override of that discretion, we do oppose that. And again, without knowing a reason why take it away. The other piece, and I was comforted by what Judge Soni said for his interpretation of the first section, section A. This would be for all the listed offenses. This is when the prosecutor and the defense are agreeing on this, that implicit in that agreement, the PSI could be part of that agreement, that's required. So we don't believe that any further language is needed there. If you take, currently it strikes the filing of the PSI, but with this assumption being made, and again, based on what Judge Soni said, that wouldn't preclude a PSI from being needed as part of that agreement, if that makes sense.
I think so. Let me just say it back, just so I'm fully understanding. So what you're saying is that a PSI could still be ordered if both of the parties agree that the PSI could be ordered.
Is needed for the agreement to move forward.
Yeah.
Which I would think so. I just wouldn't want to inadvertently. And I think that was what you were raising earlier of, this is somehow accidentally taking out the ordering of a PSI for listed offenses. And I don't believe it is, and I don't believe that's the intent.
No, I think that if both of the parties came to an agreement that they wanted the PSI as part of the deferred sentence, I don't want to speak for the judges, but I don't suspect that they would say, no, we're not going to have the PSI.
And similarly, on the flip side, again, agreeing with both the Judiciary and the Defender General, there are instances of certain listed offenses where if the parties agree, they may know the background really well of that defendant, that they could agree to move forward with the deferred without the PSI. And I think that makes sense for that flexibility of the practitioners. The other thing I just wanted to highlight for the committee just to consider when they're looking at this, with the deferred, just a reminder that when the PSI is done up front, so to speak, we have it, the deferred is imposed, meaning the defendant is now on probation with conditions. That PSI report often will help craft what those conditions are, what DOC believes are the appropriate conditions. And sometimes we're arguing over those probation conditions. So the report can be very helpful with that. The other piece is if say 6 months into that probationary period, the individual violated their probation. And that the court finds that they violated and then go to impose sentence. The PSI is already done to then impose that sentence. We don't have to have a delay on the back end if at that point the court wanted more information. So when earlier said that this would help with the backlog, maybe. But again, remembering that if the court wanted, that they don't, for misdemeanors, the court doesn't need a requirement for a PSI. For felony, it does. But the court may want that information before imposing sentence, and that would cause a delay on the back end. And if we already have the report done, again, if it's circumstances where the state's attorney believes that it's needed, why would we wait? And then without being able to go right to sentencing at the end. So we don't believe we need to remove the discretion. We appreciate the concept that potentially is making things more flexible for the practitioners. I think implied in that is that there is some inflexibility happening from the state's attorney's department. But again, we are not sensitive to any specific examples of that.
Thank you. Committee, any questions? Okay, thank you.
Thanks.
How do we feel generally about this bill?
I missed Judge Zoning's testimonies. Can you characterize that?
I would characterize it as Judge Zone suggested that it would be helpful in clearing the backlog. Essentially, it's not like a
Big deal.
yeah. It's not a magic pill that's going to fix everything, but it is one pretty minor and narrow that could clear up some of the workload that gets imposed on DOC and having to do these pre-sentence investigations for pretty minor offenses. Unless the state's attorney waives it. So that's, yeah.
So it would not be the default to have a PSI. It would be more like in an unusual instance or in the subset of cases that Ms. McManus just talked about, domestic terrorism, et cetera. The judge could order a PSI in those cases, and this wouldn't prohibit that.
Correct.
Yeah.
Yeah. So, I mean, I was contemplating attaching this to the miscellaneous judiciary bill because I think it's pretty narrow, but there are opposing opinions, and also I'm hearing that it's a better idea to, if there's a bill, keep it in the bill form. That way it's also easier for the public to follow what's getting done. So I also, we're gonna try hearing from DOC, hopefully sometime in the next few days, see if they just want to provide us with 20-30 minutes of testimony as to their thoughts on this, because they're the ones who have to actually do the work. I also know they're quite overworked. So, if this is something that helps them out a little bit, that would be good. Yeah. Any other thoughts on this?
So basically, the bill in general just simply eliminates the requirement of the PSI. And makes it optional to the courts and or the state's attorneys and defense attorneys. Right now, the way it's listed in statute, it's a requirement. It's
a requirement unless it is waived by the state's attorney.
Right.
Yeah.
But it's a requirement unless.
Yeah.
So this
And so
eliminates requirement.
Yeah, but it would still apply to listed offenses. That's the change that we.
I mean, conceptually, I favor it.
Any other? Yeah, if you
Feel the same.
all right, so there were some minor changes that we had requested, and
I'll just
yeah.
I'll join you if that's okay up here.
Oh, yeah.
Do we have copies?
Yeah.
I was not able to follow. Copies of.
Guessing-
Is there a new draft or?
No, I just did the walkthrough right before you came in. But we talked about, after we had everybody had a discussion about it. So I'll go through, and I think I kind of, want some clarity on the listed crimes. So, so subsection A is the one where there's an agreement between the prosecution and the defense.
Yeah.
Right? And you'll see there on line 14 is that there's a requirement for the pre-sentence investigation. So my question for you there is, do you want to break it out and so like have maybe a subdivision 2 that says, for offenses that are listed crimes, the court shall review a pre-sentence investigation prior
Unless-
to.
Okay, sorry.
Oh, prior to, unless waived by the state's attorney.
Yes, yeah, that's what I'm trying to get at.
Okay.
And
So again, it would eliminate the requirements for the non-listed crimes, but the court will still have the authority to be able to ask for one if they
And
feel
there would
they
be a-
need that information for
And there would be
purposes
a
of.
requirement for the listing.
Yes.
Yeah.
Yep.
and the court, and there would still be a PSI, based on what we just heard, there would still be a PSI for the non-listed offenses if both of the parties agree that there should be a PSI. Sure. Right? That's, yeah. And I think that what we heard is that that's already baked into this. I understand.
And then the one other change is on page 2 in subdivision 5. On line 11, I'm gonna unstrike the court reviews. And unstrike and the victim's impact statement of the parties, because I should have just struck the words, the pre-sentence investigation and. Because it encompasses the two things and you still have the victim's impact statement up there, so.
Well, that's easy, and hopefully we can hear from probation of the role within the next couple of days, and just to cross that off the list, but we can get those changes, I guess, before Friday.
Oh, I'll get to it as soon as I can. Things are moving fast this
Yeah.
week, I realize. So I will, sometime today or tonight, I will send something to Emery for you so that, he can pass it along to DOC before they testify as well.
Fantastic. Then we'll try to put it up for a vote. You've got a couple of blocks of free time that will, shouldn't take very long to wrap this one up, as long as there's no new issues that arise like that. So, sure. Thank you. Appreciate it. So committee, we have S 186 at 11. And we're 5 minutes early, so let's take 5 minutes.